Good morning. Thank you very much to the organisers and to the Academy for inviting us, for the warm welcome you've given us, and for enabling me to open the day with a conversation, I hope, about the state of play at the Court of Human Rights in relation to the protection of the environment and the fight, if you want to call it that, against the consequences of climate change. As we all know, this topic could, of course, not be more timely because not only did the heads of state and government of the Council of Europe in their final declaration at the Reykjavik summit in May 2023 stress the urgency of taking coordinated action to protect the environment by countering the triple planetary crisis of pollution, climate change and loss of biodiversity. They also affirmed that human rights and the environment are intertwined and that a clean, healthy and sustainable environment is integral to the full enjoyment of human rights by present and future generations. But of course also, if you look at the science and at where we are today, the European Environment Agency in its European Climate Risk Assessment published in March 2024 noted as one of its key takeaways that Europe is the fastest warming continent in the world. Extreme heat, once relatively rare, is becoming more frequent while precipitation patterns are changing. Downpours and other precipitation extremes are increasing in severity, and recent years have seen catastrophic floods in various regions. At the same time, they said southern Europe can expect considerable declines in overall rainfall and more severe droughts. Coming even closer to today, the European Union's Copernicus Climate Change Service noted in its annual climate summary published on the 10th of January this year that last year was the warmest year in a multi-data set record of global temperatures going back to 1850. And the first year with an average temperature clearly exceeding 1.5 degrees Celsius above pre-industrial levels. Now, it was in this context that almost exactly a year ago, on the 9th of April 2024, in a judgment of the Grand Chamber in the case of Verein Klimasenioren against Switzerland, the European Court of Human Rights itself formally recognized that climate change is one of the most pressing issues of our times, and that the widely acknowledged inadequacy of past state action to combat climate change globally entails an aggravation of the risks of its adverse consequences and the ensuing threats arising therefrom for the enjoyment of human rights. On the basis of this recognition, the Court, rather than seeking to follow an approach consistent with its, or consisting in directly transposing its existing environmental case law to the context of climate change, went on to develop a more tailored approach as regards the various convention issues which may arise in the context of climate change. So what I would want to seek to do this morning is to take stock where we are in relation to both of these strands of the Court's case law, which, while separate and subject to separate principles, are of course closely interlinked. But before I go into more detail, both of the Court's already existing environmental case law or the different and more tailored approach taken in relation to climate change, it may be helpful if I provide a little more by way of context and background. The first point, which may be obvious but is nevertheless worth noting, is that the European Convention on Human Rights, originally drafted in the immediate aftermath of the Second World War and the fall of Nazi Germany and its allies, was signed in 1950, and we are, of course, and again, the special occasion today, the 75th birthday this year, included, one might say, only a list of very traditional civil and political rights, including the right to life under Article 2, the right to a fair trial and access to court under Article 6, and the right to respect for private and family life under Article 8, to be protected first by the member states and their courts and ultimately by our court. Since its inception, this list of human rights has on occasion been enlarged through the adoption of numerous additional protocols, the most recent of which, in terms of substantive rights, was Protocol number 13 in 2003, which abolishes the death penalty in all circumstances. However, despite these successive enlargements of the catalogue of human rights protected under Convention, and despite repeated calls by the Parliamentary Assembly of the Council of Europe since about 1999 for a relevant treaty amendment or an additional protocol, as matters stand today, neither the Convention nor the protocols thereto contain a right to a safe, clean, healthy and sustainable environment or to the protection against climate change. Reflecting this omission, to date the Court has therefore consistently, including in Klimasenioren, acknowledged that the Convention is not, and I quote, specifically designed to provide general protection of the environment as such. To that effect, other international instrument and domestic legislation are more pertinent, end quote. However, if you search HUDOC, the Court's case law database, it shows that the Strasbourg organs, that is the Court and the now defunct Commission, have already handed down more than about 360 decisions and judgments in cases raising environment-related issues, and had done so by the time they came to consider climate change. Now, how, you may ask, can this be if no such right is enshrined in the Convention? And the answer to this question takes me to the second important point by way of background, the Court's approach to the interpretation of the Convention. Like with any international treaty, the starting point for the interpretation of the Convention and the rights enshrined therein, of course, is the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. However, as first recorded in its famous 1978 Tyra judgment, the Court has always interpreted the Convention as a living instrument, which must be interpreted in the light of present-day conditions. The Court said it cannot but be influenced by the developments and commonly accepted standards in the member states of the Council of Europe. This so-called living instrument doctrine means that the Court will have regard to the changing conditions within the respondent state and within contracting states generally, and respond, for example, to any evolving convergence as to the standards to be achieved. Just pausing a minute, and this may just be my experience as the judge in respect of the UK, but as many of you will be aware, the living instrument doctrine is frequently at the heart of the criticism levelled at the Court, including by those who advocate, not only in the current UK debate, withdrawal from the Convention. Now, there can, of course, be disagreement as to how far the Court can go in applying this doctrine, and this has, and you will be more than aware of this, been subject of much debate both in the literature and in various separate opinions attached to judgments by this Court. And in fact, in my separate opinion, in the Klimasenioren case, I myself expressed the view that the majority had gone too far. However, the concept itself is, of course, relatively uncontested, and I'm sure we will hear more about this from my colleagues, both in the context of the interpretation of constitutional statutes domestically as well as in international law. In relation to international law, the ILC working group on the topic of fragmentation of international law, in fact, concluded that the evolutive approaches to treaty interpretation are neither specific to human rights treaties, nor do they even constitute a separate method of treaty interpretation. And in the context of the interpretation of constitutional statutes, even in the common law context, from which of course I come, it was as long ago as 1929 that the Privy Council in London, sitting as the then highest court of appeal for Canada, described the 1867 British North America Act as a living tree capable of growth and expansion within its natural limits. One of the means of applying the living instrument document is, of course, also to interpret the Convention in light of and in accordance with the relevant norms and principles of public international law, and to take account of any relevant rules of international law applicable to the relations between the parties. And in this context, of course, in particular, the Paris Agreement and the UNFCCC. Now, returning to the question of the protection of the environment by means of the Convention, and the criticism just referred to, it is perhaps also noteworthy that the Committee of Ministers have consistently rejected the repeated proposals for a treaty amendment or an additional protocol over the last 25 years on the express assertion that, and I quote, the Convention system already indirectly contributes to the protection of the environment through existing Convention rights and their interpretation in the evolving case law of the European Court of Human Rights, end quote. Of course, this contribution by the court to the protection of the environment was and is only possible through the judicious application of the living instrument doctrine. Now, the existing environmental case law therefore reflects the fact that, as the court has, at least since 1991, expressly acknowledged, in today's society the protection of the environment is an increasingly important consideration. Identifying the existence and or content, however, of the common accepted standards or any evolving conversions necessary in order to develop the Convention in light of the living instrument doctrine and to define the extent to which protection is provided has, however, not always been easy. So before we look at where we are today, it may also be, as a final piece of relevant background, be worth highlighting that in principle the issue which the court has to consider in any application, which is almost invariably concerned with the application by an individual in relation to an alleged violation of his or her rights, and not with an abstract review of existing legal regimes, is first the admissibility of that application, and in this context particularly whether an applicant can claim to be a victim of the alleged violation of a convention right, and only once the application is admissible whether there has been one or more substantive violations of the convention. As we will see, certainly in the context of environmental protection and climate change, these two requirements are frequently intimately connected and in fact difficult, if not impossible, to separate. As a consequence, and to explain why that is so, I will start with the substantive protections the court has so far identified in the context of the protection of the environment, before turning briefly to the admissibility requirements. As I indicated at the outset, in Klimasenioren, the court drew a clear distinction between its established environmental protection approach and the approach necessary to address the problem of climate change, and went on to specify a special regime to address the latter. And again, I will look first at the general environmental protection regime before I look at the regime in relation to climate change. In order to fall within the scope of Article 8 of the Convention, the right to respect for private and family life and the home, complaints relating to environmental nuisances have to show first that there was an actual interference with the applicant's enjoyment of their private or family life or home, and secondly, that a certain level of severity was attained. Now, the required actual interference refers in practice to the existence of a direct and immediate link between the alleged environmental harm and the applicant's private or family life or home. In this context, the court has made clear that the general deterioration of the environment alone is normally not sufficient. There must be a negative effect on an individual's private or family sphere, which is essentially decided by reference to the same criteria applied as to the admissibility requirement for victim status. The question whether the interference has passed the necessary threshold of severity is again an assessment which by definition is relative and depending on all the circumstances of the case, such as the intensity and duration of the nuisance and its physical or mental effects. The general context of the environment should also be taken into account, the court has said. There would be no arguable claim under Article 8 if the detriment complained of was negligible in comparison to the environmental hazards inherent to life in every modern city. And again, you can see the tensions that may arise in the context of climate change. As our colleague Judge Pavli noted in his partly dissenting opinion in Hudorovic and others against Slovenia, what matters is whether the environmental hazard has caused significant impairment to one's ability to enjoy one's home, considering aspects such as the intensity and duration of the nuisance and its physical and mental effects on health and quality of life. Now, that said, it's not essential for an issue to arise under Article 8 that the applicant's health was affected or even threatened on the ground of his or her exposure to pollution or nuisance. Once these entry conditions have been fulfilled, the court will not limit itself to analysing the complaint only in terms of whether there has been an interference by a public authority with the Article 8 rights, that is, a breach of a negative obligation, but in fact the vast majority of cases in this context are concerned with whether there has been a breach of the state's positive obligations, that is, the obligation to take reasonable and appropriate measures to secure the applicant's rights. Such a positive obligation may include, amongst others, a requirement to adopt, maintain and operate an appropriate regulatory regime. In any event, no matter how a complaint is ultimately analysed, the Court has confirmed that the applicable principles regarding the balance between the rights of an individual and the interests of the community as a whole are broadly similar. But where the state is required to take positive measures, the choice of means is in principle a matter that falls within the contracting state's margin of appreciation. Now, in cases of broader policy choices, this margin of appreciation has generally been wide, leaving the Court to consider only whether there has been a manifest error of appreciation by the national authorities in striking a fair balance between the competing interests of different private actors. Due to the complexity of the issues involved, the Court has so far, at least in the context of environmental protection, seen its role as primarily subsidiary. That is, as limited to examining first whether the decision-making process was fair and afforded due respect to the interests safeguarded to the individual by Article 8, and only in exceptional circumstances has the Court gone beyond this line and revised the material conclusions of the domestic authorities. But here already we find the first divergence in climate change, because in Klimasenioren, the Court appears to have changed the perspective somewhat, away from focusing on the state, and has formulated the approach as follows, I quote, "The margin of appreciation for the domestic authorities is not unlimited and goes hand in hand with European supervision by the Court, which must be satisfied that the effects produced by the impugned national measures were compatible with the Convention," end quote. Now, whether this signifies a greater willingness on the part of the Court, at least in the context of climate change, to engage with national policy remains to be seen. As a result of the traditional approach, however, where the Court has found a violation of Article 8, this has frequently been on the basis of a failure by the authorities to comply with some aspect or other of their own domestic and regulatory regime, such as a failure of the licensing regime or a failure to comply with freedom of information legislation. However, taking the flip side of that, the Court has also made clear that a mere compliance by the authorities with the domestic regime by itself is not enough to avoid a finding of a violation of the Convention. The existence of and compliance with domestic legislation is only one of many aspects which should be taken into account in assessing whether the state has struck a fair balance in accordance with Article 8.2. Now, in cases in which environmental disasters have caused or threatened to cause a loss of life, the Court has also found, frequently in addition to Article 8, and sometimes Article 1 of the First Protocol, the protection of property, that Article 2, the absolute right to life, was engaged and has been breached. The positive obligations arising under Article 2, beyond the mere negative obligation to refrain from the intentional taking of life, include most relevantly in this context a primary substantive procedural obligation to put in place again an appropriate legislative and administrative framework, including the making of regulations to compel institutions, whether private or public, to adopt appropriate measures for the protection of people's lives. In these cases, Article 2 may well therefore apply despite the fact that there is no direct state responsibility for placing the applicant's life in danger. Now, Article 2 also imposes a further substantive positive obligation, and that is the obligation to take preventive operational measures to protect an identified individual from another, or even from themselves, the so-called Osman duty, after the case of Osman against the United Kingdom. However, again, the Court has, so far at least, significantly circumscribed this obligation. On the one hand, the Court has stressed that this obligation must be interpreted in a way that does not impose an impossible or disproportionate burden on the authorities, and on the other, it has made its application subject to the requirement that it has to be established that the authorities knew or ought to have known at the time of a real and immediate risk to the life of an identified individual or individuals. However, once triggered, this duty requires the state to take measures within the scope of its powers that, judged reasonably, might be expected to avoid the identified risk. Now, this aspect of Article 2 has most recently found expression in the context of environmental protection in the judgment of the 30th of January this year in a case called Cannavacciolo and others against Italy. That case concerned the failure by the Italian authority to diligently deal with the systematic, many-decade-long, widespread and large-scale phenomenon of the illegal and therefore completely unregulated dumping, often accompanied by incineration and burying of hazardous waste in the Campania region, the so-called Terra dei Fuochi. In its judgment, the court accepted the existence of a sufficiently serious, genuine and ascertainable risk to life to engage Article 2 and to trigger a duty to act on the authorities' part, and found a violation of Article 2. This finding was based on the fact that the government had not established that the Italian authorities had approached the Terra dei Fuochi problem with a diligence warranted by the seriousness of the situation and had failed to demonstrate that the Italian state had done all that could have been required for it to protect the applicants' lives. This judgment is of further interest in this context because, having decided to treat this case as a pilot judgment, the court gave unusually detailed indications under Article 46 of the Convention as to the general measures that need to be taken by the Italian authorities in respect of the systemic problem. Measures the court has said to be implemented within a time limit of 2 years from the date on which the current judgment became final. Now let's now turn from the substantive protection to the procedural protection under the court's case law in the context of environmental protection. In its judgment in Tashkent and others against Turkey, in the context of environmental law, the court explained that the state's procedural obligations consisted of 3 separate obligations. The court there said, where a state must determine complex issues of environmental and economic policy, the decision-making process must, firstly, involve appropriate investigations and studies in order to allow them to predict and evaluate in advance the effects of those activities which might damage the environment and infringe individual rights, and to enable them to strike a fair balance between the various conflicting interests at stake. Secondly, the importance of public access to the conclusions of such studies and to information which would enable members of the public to assess the danger to which they are exposed is beyond question. And lastly, the individuals concerned must also be able to appeal to the courts against any decision, act or omission where they consider that their interests or their comments had not been given effect or sufficient weight in the decision-making process. The specific article of the Convention that is invoked in this context is of lesser relevance, as the court has noted that in the context of dangerous activities, the scopes of the positive obligations under Article 2 and Article 8 largely overlap. However, it is also in this procedural context that some of the main difficulties the court has had to address in the context of climate change litigation arise. Looking at the domestic context first, as the court indicated, individuals concerned must be able to appeal to the courts against any decision, act or omission where they consider that their interests or their comments have not been given sufficient weight. However, when it comes to asserting or defending that right by reference to Article 6 of the Convention, that is the right of access to court and to a fair hearing, the dominant line of the court's case law makes it clear that, in fact, challenges by individuals to decisions on major environmental impact are not, in fact, necessarily covered by Article 6, because they do not, per se, engage an individual's civil rights and obligations. Now, this raises 2 questions. One, whether there is in fact a dispute or a contestation in French over a right which can be said, at least on arguable grounds, to be recognized under domestic law, irrespective of whether that right is protective under the Convention. After all, it is a consistent part of the Court's jurisprudence that Article 6 does not in itself guarantee any particular content for the civil right or obligation in the substantive law of contracting states. Now, this dispute must be genuine and serious, but may relate not only to the actual existence of such a right, but also to its scope and the manner of its exercise. The second question that is important to be addressed for the applicability of Article 6 is whether the result of the proceedings is directly decisive for the right in question. A mere tenuous connection or remote consequence is not sufficient to bring Article 6.1 into play. Generally, this means that the alleged hazard has to expose the individual personally to a danger that was not only serious, but also specific, and above all, imminent to themselves. On this latter question, one or two decisions of the court appear to have been more accommodating than the existing case law, but they do not appear to have had any lasting impact on the underlying approach on the court and have therefore left the case law in some degree of uncertainty. But as a result, on occasion, the court has sought to draw a distinction between, on the one hand, the aspects of the dispute relating to the defense of public interests, which did not concern a civil right, that the applicants could have claimed on their own behalf, and on the other, the repercussions of a decision on their lifestyles and properties, which the court held did engage Article 6. This same restrictive approach is also reflected in the case law of the court in relation to the admissibility of an application to the court under the Convention more generally. Now, this is governed by Article 34 of the Convention, which provides that a court may receive an application only from an applicant claiming to be the victim of a violation of the rights set forth in the Convention. To date, this requirement has generally been interpreted by the court, and I quote, autonomously and irrespective of domestic concepts such as those concerning an interest or capacity to act. In addition, in order for an applicant to be able to claim to be a victim of a violation of a convention, there must be a sufficiently direct link between the applicant and the harm which they consider they have sustained on account of the alleged violation, close quote. In this context, again, the recent judgment in Cannavacciolo is instructive. In that case, it concluded that on the basis of the evidence and bearing in mind the particular nature of the pollution phenomenon at issue and the conduct giving rise to it, the court accepts the existence of a sufficiently serious, genuine and ascertainable risk to life to engage Article 2 of the Convention and trigger a duty to act on the authorities' part. The court also accepted that the risk may be considered imminent in the terms established by the court's case law, given the applicant's residence over a considerable period of time in municipalities identified by the state authorities as being affected by the pollution at issue, which had been ongoing, omnipresent, and unavoidable for decades and had not ceased at the time the applications were lodged with the court. The court said, being satisfied that the applicants were exposed to a risk thus described, it does not consider it necessary or appropriate to require that the applicants demonstrate a proven link between the exposure to an identifiable type of pollution or even harmful substance and the onset of a specific life-threatening illness or death as a result of it, end quote. Now, on the other hand, as implicitly recognized by the court in Klimasenioren, one of the consequences of this established focus on a serious, specific and imminent risk to an applicant, of course, poses a very real obstacle to litigation brought by public interest organizations and non-governmental organizations, unless they can show, for example, that they were set up for the specific purpose of defending their members' interests before the courts, and that those members were directly concerned by the decision at issue, or that the domestic judgment in their favour had not been executed. But this latter situation, this position in relation to non-governmental organisations, was of course not an inadvertent development of the court's case law or an unintended limitation of access to the court. Quite the contrary, the court has consistently held under Article 34 that it does not allow in abstracto complaints alleging a violation of the Convention. It said the Convention does not provide for an institution of an actio popularis, meaning that applicants may not complain against a provision of domestic law, a domestic practice or public act simply because they appear to contravene the Convention. In order for applicants to be able to claim to be a victim, they must, as we've heard before, produce reasonable and convincing evidence of a likelihood that a violation affecting them personally will occur. Mere suspicion or conjecture is insufficient. This remains the position in relation to general environmental protection cases, despite and because of the Grand Chamber judgment in Klimasenioren, which I will turn to now. The new, more tailored approach the court adopted in relation to climate changes, as we will see, differs from that just described in two important aspects. The first is in relation to the need to show victim status and or to the standing of applications by non-governmental organizations, both domestically as well as in Strasbourg, and secondly, in defining more specifically a positive obligation imposed on the member states under the Convention. In relation to the question of victim status and of the traditional need to show a direct impact, or at least a real risk of a direct impact on the individual applicant, the Court again in Klimasenioren stressed that the Convention did not allow for an actio popularis. To safeguard this principle, the Court, in relation to individual applicants, therefore not only restated the existing test, but identified a newish test which it described as especially high. That test is that an individual would have to show that, 1, they are subject to a high intensity of exposure to the adverse effects of climate change, that is, the level and severity of the risk of adverse consequences of governmental action or inaction affecting the applicant must be significant, and secondly, there must be a pressing need to ensure the applicant's individual protection owing to the absence or inadequacy of any reasonable measure to reduce the harm. Now, whether this is, as asserted, a higher threshold than the one that applies more generally in environmental cases will remain to be seen in future cases. In any event, the individual applicants in Klimasenioren were held not to have satisfied this test. The more fundamental development in this context, however, is that in relation to the standing of associations and NGOs to bring proceedings before the domestic courts and ultimately the Strasbourg Court. The Court, while reiterating that an association cannot rely on health considerations or nuisances and problems associated with climate change which can only be encountered by natural persons, the Court held, and I quote, that the specific considerations relating to climate change weigh in favour of recognising the possibility for associations, subject to certain conditions, to have standing before the Court as representatives of the individuals whose rights are or will allegedly be affected, end quote. These specific considerations included the realization that complaints may concern acts or omissions in respect of various types of general measures, the consequences of which are not limited to certain identifiable individuals or groups, but may affect the population more widely. Now, drawing its inspiration from the Aarhus Convention, the Court therefore identified the following standing rules for associations and NGOs. They must be 1, lawfully established in the jurisdiction concerned or have standing to act there. 2, be able to demonstrate that they pursue a dedicated purpose in accordance with its statutory objective in the defence of the human rights of its members or other affected individuals within the jurisdiction concerned, whether limited to or including collective action for the protection of the rights against the threats arising from climate change. And thirdly, they must be able to demonstrate that they can be regarded as genuinely qualified and representative to act on behalf of members or other affected individuals within the jurisdiction who are subject to specific threats or adverse effects of climate change on their lives, health or well-being as protected under the Convention. Now, what seems noteworthy in this test is, as formulated by the Court, is that it seems to give associations standing even if or where neither the association nor any of its individual members can or could satisfy the victim test of direct impact. Now, how far the Court will look at or require an association to show that there is any individual within the jurisdiction of the respondent state who is subject to specific threats or adverse effects of climate change on their lives, health or well-being will again remain to be seen. On the one hand, such a requirement would of course be consonant with the stated objective not to allow an actio popularis. But on the other hand also, such a requirement might be said to render the standing sought to be afforded to non-governmental associations virtually ineffective. As applied to the facts of the case in Klimasenioren, the grant of standing to the corporate applicant in that case would suggest that no such requirement is likely to be imposed. Now, this development of the approach to standing was at least in part motivated by the fact that, and I quote, the individual applicants did not have access to court in the respondent state and viewed overall the grant of standing to the applicant association there before the court is in the interests of the proper administration of justice, close quote. It will remain to be seen how this plays out, in particular in national systems and, where applicable, before the Court of Justice of the European Union, which of course do not currently provide for such standing of associations. Where that is so, the question arises whether, as there is no effective domestic remedy to be exhausted, the Strasbourg Court will find itself having to act as a court of first instance. Now, in its judgment in the Cannavacciolo case, which I mentioned, the court confirmed again that this recognition of standing of association was only justified by the specific considerations relating to climate change and the special feature of climate change as a common concern of humankind and the necessity of promoting intergenerational burden sharing in this context. It was therefore to be limited to that specific context, and the applications brought by associations in relation to the Terra dei Fuochi phenomenon were held to be inadmissible. Turning now to the question of substantive rights, the judgment is noteworthy because, and this is Klimasenioren, is noteworthy because the court identified for the first time that Article 8 and arguably Article 2 of the Convention provided for a right for individuals to enjoy effective protection by the state authorities from serious adverse effects on their life, health, well-being and quality of life arising from the harmful effects and risks caused by climate change. According to the court, this right finds expression in three ways. One, it imposes on the state a primary duty to adopt and to effectively apply in practice regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. That is, to undertake measures for the substantial and progressive reduction of their respective greenhouse gas emission levels, with a view to reaching net neutrality within, the court said, in principle, the next 3 decades. The court went on to say that in this context, in order for the measure to be effective, it is incumbent on the public authorities to act in good time and in an appropriate and consistent manner. Secondly, these mitigation measures must be supplemented by adaptation measures aimed at alleviating the most severe and imminent consequences of climate change, taking into account any relevant particular needs for protection. Such adaptation measures must be put in place and effectively applied in accordance with, the court said, the best available evidence and consistent with the general structure of the state's positive obligations in this context. And the third requirement is that there are certain types of procedural safeguards, namely A, information of importance for setting out and implementing the relevant regulations and measures to tackle climate change, as well as the conclusions of relevant studies, must be made available to the public, allowing them to assess the risk to which they are exposed. And B, procedures must be available through which the views of the public can be taken into account in the decision-making process. As I indicated earlier, in the context of general environmental cases, the court had, at least in the past, allowed the states a wide margin of appreciation in relation to the measures they chose to take in order to comply with their positive obligations towards the applicant. In the context of climate change, the court again adopted a more differentiated approach. As a result, it held that states, one, have a narrow margin of appreciation in respect of their commitment to the necessity of combating climate change and its adverse effects, and the setting of the requisite aims and objectives in this respect, based on the nature and gravity of the threat and the general consensus as to the stakes involved in ensuring the overarching goal of effective climate protection through overall greenhouse gas reduction targets in accordance with the contracting parties' accepted commitments to achieve carbon neutrality, which call for, the court said, a reduced margin of appreciation. And secondly, the court said there is a wide margin of appreciation in respect of the state's choice of means, including operational choices and policies adopted in order to meet internationally anchored targets and commitments in the light of priorities and resources. Ultimately, on the facts of the case, the court decided that Switzerland had failed to put in place adequate mitigation measures and indicated that there were some critical lacunae in the Swiss authorities' process of putting in place the relevant domestic regulatory framework, including a failure by them to quantify, through a carbon budget or otherwise, national greenhouse gas emission limitations. Now, in passing, it's perhaps worth noting that in the context of the examination of the measures taken by Switzerland in execution of this judgment, the first consideration of which took place in the CMDH in March of this year, one of the key issues appears to be the need for the adoption by Switzerland of a carbon budget on the basis of a fair level of contribution. Now, while Switzerland confirmed that it had adopted a first carbon budget, the Swiss government in their submissions firmly rejected, as they also did, as did the EU before the ICJ in its hearings on the advisory opinion in relation to climate change. They strongly rejected the suggestion that the definition of a carbon budget is in fact an obligation under international law. Whether drawn generally or from the Klimasenioren judgment, because, as they said, there is currently no internationally recognized method of allocating global emission that is accepted by the international community. Now, the CMDH left this question open and only invited the authorities to provide further information on the implementation measures and to further demonstrate that the methodology used to devise, develop and implement the relevant legislative and administrative framework responds to the Convention requirements as detailed by the Court and relies on a quantification through, and I quote, a carbon budget or otherwise, end quote, of national greenhouse gas emission limitations. Now, in its judgment, the Court had also made clear that the failure by the state to comply with the mitigation aspect of its positive obligations would suffice for the court to conclude that the state had failed to comply with its positive obligations under Article 8 of the Convention, without it being necessary to examine whether the ancillary adaptation measures were put in place. As a result, it is clear that a state cannot avoid the necessary and necessarily expensive and politically difficult and controversial mitigation measures by only adopting adaptation measures in relation to any or all persons directly affected by the consequences of climate change. As the approach to standing already suggested, the right identified by the court goes way beyond the protection of the individual complainant, but is focused on, I quote, immediate action and adequate intermediate reduction goals for the period leading to net neutrality, as well as on avoiding a disproportionate burden on future generations. Now, by definition, and despite this having been welcomed and or rejected as a major leap in climate change protection, this judgment is, of course, only the first step along the road of developing the finer details of the requirements which the Convention has been held to impose, and of the means by which and the detail in which the Court and the Committee of Ministers in its CMDH formation are ultimately willing or able to oversee and enforce compliance therewith. Now, before concluding, and I see my countdown, before concluding, let me just make one final point. I mentioned at the outset that since 1999, the Parliamentary Assembly had repeatedly made proposals for an amendment of the Convention or for an additional protocol. The most recent such proposal, made in September 21, had in fact included a draft text of such a protocol, which was intended not only to guarantee a substantive right to a safe, clean, healthy and sustainable environment for everyone, but also to provide for a number of procedural rights. Importantly, and this would have been a first for an additional protocol to the Convention, it was proposed that the protocol should also set out certain principles as interpretative guidance, such as the principle of transgenerational responsibility, equity and solidarity, the principle of environmental non-discrimination, and the principles of prevention, precaution, non-regression, and in dubio pro natura. Now, while the Committee of Ministers had immediately instructed its Steering Committee for Human Rights, the CDDH, to engage with this proposal and study the need for and feasibility of a further instrument on human rights and the environment, it appears that following the adoption of the Klimasenioren judgment, that work was designated a background document, and a new feasibility was initiated. That new feasibility study was adopted on the 29th of November 2024 and is now before the Committee of Ministers for the necessary political decisions to be considered at a forthcoming meeting. Now, perhaps interestingly, the CDDH feasibility study includes detailed consideration of the following options: an additional protocol to the Convention, or in fact to the European Social Charter, in one of three models, merely guaranteeing the right of to a healthy environment without specifying the constituent elements; 2, guaranteeing such a right with a definition of its constituent elements; or 3, guaranteeing such a right and defining not only its constituent elements, but also additional elements such as jurisdiction, victim status, NGO standing before the court, and the assessment of evidence. Second model considered was the creation of a new monitoring mechanism. The third, the inclusion of a reference to environmental protection in the preamble. The fourth, a non-binding instrument recognizing such a right. And the fifth, a combination of these as well as not adopting any new instrument. You won't be surprised to hear that the study does not, in fact, express any preference. But it does record that there is a range of views in the CDH on the question of both the need for a further instrument and the feasibility in terms of advantages and disadvantages of the various options. It appears that, and I quote, some member states consider that the court's development of its case law, interpreting and applying existing convention rights, will be a commensurate response to the human rights impact of the triple planetary crisis, close quote. While others consider, and I quote again, that the scope of the development of new legal standards that is needed goes beyond what the court could reasonably be expected to do under accepted principles of judicial interpretation of the Convention, and that it should be for the member states to determine the essentially normative content of new legal standards, in particular the human right to a healthy environment, close quotes. One issue that is, however, clearly identified in the feasibility study is that even if the political decision were to begin the process of drafting a new protocol, that process of adopting a protocol and its entry into force can be protracted depending on which model is adopted, with the more complex versions requiring more consideration and a limited number of ratifications of a new protocol affecting the geographical scope of its protection in public. This would be even more of an issue, of course, if the protocol sought to insert a mention of environmental protection in the preamble of the Convention, as was last done with Article 1 of Protocol number 15, because a protocol amending the existing preamble would have to be ratified by all member states in order to enter into force. This process is time and resource intensive at both Council of Europe and national levels. Now, as you can see, both on the legislative front as well as through litigation, the question of human rights and the protection of the environment and protection against the consequences of climate change remains very much a space to be watched. Thank you very much.
Thank you very much. First, a big thank you for keeping the time. And thank you for your presentation. Actually, the questions that were put beforehand mainly concern the difference between the two cases, so Klimas and Eolinen and the contractual. So you already explained a bit, but could you elaborate a little bit more on the big difference, how the court deduced that in climate change, there's a general principle of being affected, while in the case of the excessive pollution, even somebody who was living in the next village couldn't claim to be direct. This is maybe not entirely clear to everyone.
Yes. Thank you for that question. Puts me right on the spot. It is a difficult distinction to make. I think that the realization in Közép-európai was that this was a phenomenon and a risk to health which was known by the Italian authorities for decades. They had recognized and designated certain regions as affected and then had not done or had ineffectively sought to address that problem. Of course, those who reside there were ultimately, before our court, confronted with the same difficulty. They couldn't show the direct link of the pollution to an illness or a damage to their to damage to their health, or in the case of those who were bringing representative action, to the death of their loved ones. But I think the view was taken by the court unanimously in that chamber judgment that in fact the causal link between the pollution and the inactivity by the state to recognized, by lots of expert evidence, recognized health impacts was so much clearer than it was in the context of climate change, by which we are of course all affected, and the impact of the inactivity. It is a question of nuance in the end, and I don't think a bright red line can be drawn. And I've seen that in the blogosphere that was already heavily discussed, including with the remark that it was surprising that I was in both compositions, because of course I was the dissenter in Klimasenioren, but was part of the unanimous judgment in Cannavacciolo. So I don't think that's probably not a particularly helpful answer, but it is a question of nuance, which shows the kind of direct link between a known source of pollution and the inaction by the state to do something about it over decades. One of the interesting aspects one may want to look at, and you may want to look at, is then how we dealt with those who brought representative actions about by the time by which they should have known or could have known that the death may have been causally connected to this pollution. And there we drew a line effectively 4 months from this kind of becoming known, that we took a fairly strict line.
Well, thank you very much. Actually, I've been to Caserta in the given period, so I tried the opportunity. It was not fun, being surrounded by waste all the time.
But of course, sorry, can I just, I mean, that of course is the problem with Campania to some extent is Campania has been the subject of various judgments. This isn't in fact the rubbish that's on the street. What we're talking about here is toxic waste, which frequently, not only, but frequently by criminal enterprises is buried or burned. So it's not, there have of course also been Campania environmental cases about the rubbish that was left on the streets and the absence of sufficient waste disposal facilities. Those are different. I mean, this was a very particular context. Yeah,
sure. When we look at the jurisprudence of the European Court of Human Rights regarding waste and waste dumping, indeed, this Italian judgment is a new step. I mean, when we look at the previous ones.
Absolutely.
Absolutely one. So, and you mentioned also the climate change issues. It's the good news. You mentioned that 2024 was the warmest year for Europe. So far, in Hungary at least, we have more than 50% more rain than last year, and more than 2 degrees Celsius less. You know, the average temperature so far. The first months. But indeed, climate change is something that the European Court of Human Rights turned its attention to. And you also mentioned the ICJ and in the international context, and it is something that is very different in the European countries and the attitude that is, well, in other sides and other parts of the world. So, what do you think? Is the climate change issue is it going to continue in the European Court of Human Rights without the protocol? So, I'm going to have one question on the protocol. What do you think it's going to be? Because biodiversity is also part of the triple planetary challenges and also the pollution that we mentioned. So how far can the court go with this living instruments principle when addressing issues that are actually not only Europe's problem, but global problems?
Well, I mean, I think the kind of deployment of the living instrument doctrine has happened. So it's now a question of fine-tuning what Klimasenioren means. One of the things that I've found surprising is, and one of the concerns I expressed in my separate opinion was that there would be a lot of litigation where we might be a first instance court, as I indicated. But in fact, as I understand it, we've only had one fresh application relating to climate change in the last year, which surprises me. I think climate change litigation will go on. I think in the European context, of course, I mean, in a sense that's quite differentiated because, of course, our Europe is bigger than the European Union, so that will go on domestically. But I think the member states are having to work out what the obligations from clean as ignorant actually mean and try and put that into place. It's really interesting if one reads, and those of you who want to study this in detail, if one reads the submissions, both written and oral, of October and December last year of the EU member states or the European states before the ICJ, and how much they do or do not either refer to Klimasenioren or to the two decisions that came with it, Carême against France and Duarte Agostinho against Portugal, is quite instructive. And I think what we will see, so I think that we will see more litigation. I think the focus looks like it's shifting to private law litigation rather than public law human rights, kind of traditional human rights litigation by our courts. It'll be suing big polluters, as we've seen with the Shell action in the Netherlands and the RWE action in Germany and various other pieces of litigation like that. And I think people are at the moment waiting to see what the ICJ says, because they've had, of course, also they heard from those states who are most impacted, because while Europe may not be the biggest polluter, historically probably with our historic burden, it probably is one of the bigger guilty parties in this game, if you want to call it that. But they also heard from the Pacific Islands, which are about to drown, who, of course, have no standing before us or before our courts. In that sense, it's quite difficult to see how they could ever be represented or be taken into account in a really effective way by the Court of Human Rights.
Well, thank you. Last question about the protocol that you mentioned. So, what are your feelings? How do you think? Is it possible when you see the Committee of Ministers and when you see these options that you mentioned in a few years' time? Do you see it coming, or you're rather skeptical?
I'm not sure it's for me to say as a judge what I think, but
yeah, it was unfair for me.
No, but I think the reality is this, and again, I did allude to this in my separate opinion, that by publishing our judgment a year ago, we effectively cut short a process where those who are the legislature in the context of the convention, namely the member states, were considering what to do in that process. We cut that short. The new process now, with what they've just adopted and what's now before the committee ministers, of course, has to be seen in light of the fact that there is now Klimasenioren as a judgment. And one has to ask the question, how far can the member states, even if they were to agree a protocol, two, all ratify it, and those are two big ifs. If they could do that, how far they can affect the development of the Klimasenioren and case law? I mean, can they, the question has to be, can they truly, through a protocol, kind of try and limit the impact of something which the court has, as a matter of its case law development itself, created? Now, there is maybe an argument, as I said, I mentioned the Article 1 of Protocol number 15, which introduced the subsidiarity concept into the preamble of the convention. Now, politically, a lot of the protagonists in that development would say, well, that's effectively putting the court back into a box. But I think the reality is that the court had always applied subsidiarity. It was putting a label into the convention of something that was court practice already. So I think there's a real question how far legislating after the event you can kind of put that genie back into the bottle, so to speak.
Well, thank you very much. Thank you for this whole morning. And now I invite you to a coffee break of 20 minutes. And please, you can find at the venue of the cafe the books that were mentioned beforehand by Professor Szilágyi. So please use these few minutes to refresh yourselves, and then we continue. Thank you very much.
Thank you very much.